Egun hone guztioi. Gaur lehenengo hitzaldi biak izango dira Europako ikuspegia eta gero Kastilako ikuspegitik, beraz, ikuspegi orokorretik hasiko gara gure hitzaldiak beharrezkoa iruditzen zaigu. Bueno, zabaldu. Eduardo. Laburpena da, zera horren laburpena orain zabaltzeko, gero igual hartu nahi izango duzue. Gure helburua, Kongresua diseinatzerakoan nahi genduan Europako ikuspegi bat izatea. Zer dira asamblea representatiboak? Asamblea representatiboak Europako kultura politikoan sartu dagoelako 16. mendetik. Eta lehia hori koroarekin zein izan zen. Horregatik lehenengo hitzaldia izango da Seawardek emandakoa on constitutionalism, pactism and the origin of the political assemblies and limited governments. Zelan mugatzen diren gobernamenduak. Beraz, iraganeko gauza pentsatu daiteke dala, baina gaur egunekoa ere bai, asamblea representatiboa eta gero botere ejekutiboen arteko lehia gaur egunean mundu guztian agiri zaiguna. Nor da Paul Seaward? Paul Seawardek izan da zuzendaria de Histórico Parliament Trust Londonen, oinarrituakoa 2001-tik 2023. Histórico Parliament proiektua 1929an hasi zen, Britaniako parlamentuan eragindako erakunde bat, eta parlamentuan historiak aztertzen ditu. Ondoren izen da Fellowship Christ College Cambridgeen, doktoregoa 17. mendeari buruz egin dau, eta baita ere, beste berizkuntza bada, parlamentuko langile izan da, urte luzez, History o Parlamenten proiektua eutzi horretik. Berak beren liburu taiko batzuk Jovesen edizio kritiko batzuk argitaratu ditu, eta baita ere Clarendon lanak Oxforden une honetan berak prestatzen ari da. Voy a presentar a Paul Seaward. Muchas gracias por estar y compartir con nosotros esta lección inaugural de este Congreso. El objetivo de de incorporar esta visión general hemos visto necesaria, pues las asambleas representativas no es una estructura privativa de Bizkaia, sino justamente era un sistema ordinario general en Europa. Y en esa visión general creemos necesaria una intervención también de la perspectiva de qué sucede en Europa, en particular ya en el Reino Unido, puesto que fue en el Reino Unido donde el Parlamento se impuso al poder de la corona en 1688. Paul Seaward, director de History Parliament Trust del año 2001 al 2023, y este es un proyecto de investigaciones sobre la propia institución, sobre la institución del Parlamento inglés y británico, y aparte de ello ha publicado numerosas, su especialidad es el siglo XVII, numerosos ensayos, ediciones críticas del pensamiento y de la obra de Thomas Hobbes. En este momento prepara edición de Clarendon en Oxford. Su ponencia justamente se titula sobre el constitucionalismo, el pactismo, los orígenes de las asambleas representativas y los límites y los sistemas de limitación de los gobiernos. No es un tema, por tanto, del siglo XVI, es un tema, en la historia siempre estamos en sistemas de actualización, es un tema también del siglo XXI. Y sin más preámbulos, muchas gracias por estar y compartir con nosotros y agradecidos por esta conferencia. Y el resumen lo repartiremos luego y cedo la palabra, por lo tanto, a Paul Seaward.
Thank you, Josipa, for that very generous introduction, and especially for inviting me to come here to speak to you at this very important and very interesting conference. I apologize that I will speak in English. I'm afraid my Basque is certainly not good enough, and my Spanish is not good enough either to speak to you, but I hope I can speak in a slow enough way for it to be comprehensible. In the late Middle Ages and early modern period, the Señorío of Biscay and the English monarchy are models of very different constitutional arrangements. The first was a self-governing enclave within a kingdom with its own political assembly and its own laws, claiming, in theory at least, a right to elect its lord and an exclusion from obligations that applied to most of the other parts of the Castilian realm. Its basic privileges and freedoms, as well as its laws, were recorded in the distinct documents that we celebrate today. The second was a centralized hereditary kingdom which possessed a single political assembly and, broadly speaking, a single legal system. The two seem hardly comparable, not surprisingly, since both of them are commonly regarded as unusual, if not unique. On the one hand, Biscay's level of autonomy and its long survival within the Spanish monarchy made it highly anomalous within a Europe of increasingly centralized nation states. On the other, England's early centralization marked it out from most other European polities, particularly the composite monarchies in which kings ruled over a patchwork of local powers and jurisdictions, partly autonomous territories operating under their own individual agreements. The differences between the constitutional arrangements of England and Biscay reflected the difference between the unmediated power that English kings could exercise throughout a realm that had already been more or less a jurisdictional unit for 300 years, and a Spanish realm that was still very much in the process of construction through the consolidation of units that had been separate for about the same period. In both Biscay and England, though, power was limited by explicit or implicit understandings between the ruler and the political community. Such constitutional agreements were common throughout early modern Europe, even if they took highly distinct forms in different places. In Spain, they are commonly referred to as pactism. In England and Britain, constitutionalism. In this lecture, I want to explore these two traditions, Spanish pactism and English-British constitutionalism. My aims are limited, comparing different constitutional systems in the past, and explaining the difference is always problematic. Arrangements in different countries are extremely complex, the result of differing histories and a huge range of differing pressures and influences. Exploring all of these variables would be well beyond the capacity of a single lecture. Historians have often and reasonably been reluctant to try to generalize about these widely differing institutions and situations. My ability to do any such thing is anyway compromised by the extent of my own expertise. I'm a historian of the English and British system, and my knowledge of either the Basque constitution or those elsewhere in Spain is far more limited than the expertise available in this room. So this lecture will be more of an interpretation of the English system through the prism of late medieval and early modern Spain, in the hope that you will find it possible to do the reverse process and think about the Spanish examples through the prism of the English and the British. I'm keen to show that while there are many differences between such systems, they are all dealing with the same questions, often in very comparable ways. I'd like to suggest that the tendency to consider the history of representative institutions and political assemblies in England, Britain, and in the rest of Europe as very distinct subjects is an obstacle to a broader understanding. I'm conscious that there are probably elements of Spanish and Bizkaian systems that I have misunderstood, so in advance, apologies, and I hope you will correct me in our discussion later. What do these terms mean? Pactism, though it has become common in Spanish historiography, is a word never used in English, and even in Spain it covers a wide variety of arrangements, with the Bizkaian system perhaps the most particular of all. As I understand it, the term is derived from the term leyes paccionadas, which relates to laws made by agreement between kings and the three estates, and which could only be abolished through the same process. It has been used to describe contractual or semi-contractual agreements between a ruler and a political community, which set out the community's acceptance of the authority of the ruler and the ruler's respect for certain privileges and rights retained by or conceded to the community, usually registered through a fueros. These written documents largely reflect more ancient understandings of customary law and the conventions of rulership. Such agreements exist between a king and multiple bodies within his kingdoms. They are part of what early modern historians have called a polysynodal or polyhedral system. English and British constitutionalism possesses no very clear definition either, and the term is often used cautiously, since there is no single document on which one can rely on this as the source of a constitution in which a pact or a contract is recorded. The nature of the respective rights and obligations of sovereign and subjects were periodically the matter of vigorous argument. Yet the word reflects an ancient understanding that the English monarchy was a limited one and that kings were expected to rule within a set of laws inherited from antiquity and, broadly speaking, with consent. And therefore, Spanish pactism and English constitutionalism are clearly related ways of expressing the reciprocal nature of rule in many kingdoms within late medieval and early modern Europe, in which obedience and service is provided on one side in return for respect for laws and privileges. Both pactism and constitutionalism are embedded in forms of monarchy that reach back to antiquity and constitute two different dialects of a common language, which is often underappreciated in explorations of European political thought, a parallel and related strand to the learned, classical-inspired language of mixed forms of government. While constitutionalism and pactism focus on customary law, in both cases they are mixtures of customs inherited within the community and external influences, often the creative lawmaking of kings and their legal officials, sometimes, especially in Spain, incorporated from or influenced by Roman law. They're supported by institutions with similarly complex origins, in part based on customary practices of political assembly, in part created by kings to fit different circumstances. English constitutionalism has several sources. Some recent historiography has stressed the influence of the practices of the pre-Norman kings, the Anglo-Saxons before the Norman conquest of 1066, and has related these to the operation of the Carolingian monarchy in France and Germany. These included features of the royal coronation procedures, The acclamation of a new king by the people was an ancient feature of the coronation service. The ceremony used by the Norman and Angevin kings in the 11th and 12th centuries included a formal question presented to the congregation whether they were willing to submit to the king and to carry out his commands. The coronation oaths sworn by English kings from before the conquest contained a promise to govern with justice. The oath sworn by Henry I in 1100 included a statement that he would uphold the laws of Edward the Confessor, the king immediately preceding the 1066 conquest. From the coronation of Edward II in 1308, the oath also involved a commitment to uphold the laws and customs which the community of the realm have chosen. The implications of a king failing to meet these standards were never stated in the oath itself. If there was a hint in some of these procedures of the election of a monarch or the possibility of rejecting a monarch who failed to keep to his commitments, it was not something that was explicitly accepted by any contemporaries, although much later, in the 17th century, the oath to uphold the laws that the community of the realm had chosen was claimed to be the basis for a contractual model of kingship and ultimately for the king's subordination to Parliament. The Magna Carta of 1215 was a crucial, though not at all a comprehensive document. While it protected certain principles, in particular consent to taxation and the right to due process in legal proceedings, it was far from a full legal code along the lines of the great series of Spanish fueros of the 13th century. Much English property, criminal and commercial law had already been set out in separate statutes during the reign of Henry II in the 1160s and was reinforced by another series of statutes in the reign of Edward I from the 1270s to the 1290s. Nevertheless, Magna Carta came to be seen as a crucial confirmation of a basic commitment to rule by law and a statement of the fundamental rights and privileges of English freemen. It and other related laws were confirmed multiple times in the 13th and 14th centuries in return for an agreement to taxation or other concessions. The origins of Parliament are no easier to pin down. Conventionally, they are dated to the mid to late 13th century, with the participation of the commons as representatives of the towns, as well as the lesser nobility or knights. But historians have recently shown how it was built on earlier forms of assembly and conventions of consent that are again traceable back to the 10th century and Anglo-Saxon kings. We have references to both councils, royal councils, the Witan, and larger assemblies, the mysterious Mikkelgemot, a larger assembly. But in its 13th century form, Parliament developed from the more formal sessions of the royal court to which all the nobility were invited. At no point does any of this become a formal agreement or contract, but Magna Carta stated that taxation required the community's consent. It provided a highly respected statement of constitutional doctrine that the king found it very difficult to ignore, and which helped to encourage the development of Parliament into a forum in which that consent could be provided. Beyond this, English constitutionalism was bolstered by generations' worth of experience and habit in the relationship between ruler and subject. Much of English law continued to develop through the individual decisions of the judiciary, the evolving processes of the courts, and parliamentary statutes. The frequency with which parliaments were held in the 14th and 15th centuries similarly helped to build up a sense of Parliament as a major institution of government. How close was this to the origins of pactism in Spain? Many of the same features were present in the medieval Spanish kingdoms. The coronation oath could carry much more implications of election, though, than it did in England. In Valencia, for example, in 1261, the king was required to take the oath explicitly before the courts, with a commitment to respect their laws as well as the privileges, usages and customs of the kingdom. It was followed by his formal recognition as king. The fueros in some senses are not very different to the great statutes of Henry II and Edward I, although these statutes did not in general deal with matters of constitutional law. Courts and cortes and other assemblies were similarly linked to royal courts as in England, but some, like the English parliaments, had clearly inherited some of the traditions of early bodies. In very broad terms, then, there is much commonality between the origins and sources of pactism and constitutionalism. But when one starts to consider the way in which political assemblies relate to a political community, English constitutionalism and Spanish pactism take slightly different forms. Contracts and pacts have to be between the ruler and a body, or perhaps a person, who can be recognized as a representative of the whole community. The concept of community is a difficult one, for communities can exist at numerous levels, and as the community becomes larger, it can only be collected together through some form of representative assembly. In the English case, the principle and practice of representation was developed very closely with the concept of the community of the realm, communitas regni, and both are central to the elaboration of the parliamentary idea. The recognition of the kingdom as a community probably goes back much further, but the phrase appears first in the rhetoric of the leaders of the baronial opposition to the misgovernment of Henry III in the 13th century. In that context, in the document outlining the baronial demands, known as the Provisions of Oxford of 1258, it described a party, a side in a dispute, in which the king was on the other side. But it also referred to a collective territorial identity whose inhabitants had interests in common and a shared sense of the common good. Parliament was, in the 13th century, recognized as the place where that collective identity had its practical expression. The idea of representation is, of course, central to our understanding of the development of parliaments. Indeed, we have historically tended to define a parliament through the concept, resting on the relationship between the local and the national community and the practice of choice and communication between them. The English Parliament is usually seen as dating from the moment when an assembly of magnates and courtiers was extended to incorporate delegates elected by certain towns, as well as the knights chosen from each county. The relationship between Parliament and the representation of the community is not simply a matter of the election of representatives, though. Recent research has suggested that Parliament incorporates practices and traditions that date from before the 13th century, before even the Norman conquest, so before there is any evidence of a formal process of election. The assumption that new law, for example, needed to have the assent of the community registered through the assembly is identifiable well before 1200. The relationship between representative and represented initiated through election is nevertheless the most significant element of how we view the engagement of local communities through Parliament with the affairs of the territory as a whole. The origin and early practice of election is still very obscure. The local political community was probably originally determined by status as a landholder. In the early 15th century, the right to participate in elections was fixed at possession of land of a certain value. Elections were held in county courts and in town councils. By the late 14th century, we hear of disputes over the outcome of the elections. Occasionally, there is evidence of political discussion about national issues taking place at this level. Though it's difficult to know for certain, this is perhaps an indication of a multi-level system of governance going on, not dissimilar to the later multi-level system of Sejm and Sejmix in Poland, Lithuania, and perhaps the local political communities of cities and towns in Bizkaia. The relationship between political community, parliament, and the consent of the kingdom as a whole was a far from perfect one, and we can glimpse in England how sometimes it would be more convenient for kings to deal with local communities on an individual basis rather than through parliament. Occasionally in the 14th century, the crown would conduct tax negotiations outside parliament with the merchant communities of towns and cities, either separately or together, a practice that hinted at the way in which the Castilian cities would ultimately deal with the crown separately. In England, the clergy too remained to some extent outside the parliamentary process, for despite the presence of senior clergymen within the Lord's Chamber and until the Reformation of representatives of the lower clergy and the Commons, they conducted their own negotiations with the Crown relating to taxation in the context of their own assembly, convocation, an arrangement which lasted until the 17th century. There were parts of the country that were excluded. The County Palatine of Chester possessed its own assembly, which approved its own laws and taxes, and took no part in the English Parliament until 1542. The Principality of Wales was not formally united with England and allotted places in Parliament until the same time. It was not until 1673 that the other County Palatine of Durham in the north started to participate in Parliament. Scotland, of course, was a completely separate kingdom, even after the union of the crowns in 1603, and it was a century before parliamentary union was established to create a single nation in 1707. Apart from Scotland, though, such exclusions were relatively minor, and the idea of the close identity of the community and the assembly was established well before it was most elaborately and famously expressed by the royal official and humanist Sir Thomas Smith in his De Republica Anglorum, written in the early 1560s. Parliament, he wrote, represents and has the power of the whole realm, both the head and the body. That every Englishman is intended to be there present, either in person or by procuration and attorneys of what preeminence, state, dignity or quality soever he be, from the prince, be he king or queen, to the lowest person in England, and the consent of the Parliament is taken to be every man's consent. That idea that the individual representative could pledge his community's consent is the essence of the representative principle, and it's the critical element within the parliamentary system as it developed within England. It's a commonplace that there was no single political community of the same sort in Spain. The complexity of the Union, the diversity of its kingdoms, cities, and provinces inhibited any natural concept of a kingdom-wide political community or its representation through a single assembly. Representable political communities did exist within the individual kingdoms, and in these, the relationship with the political assembly and the representative function could be described in similar ways to the way Thomas Smith referred to the English Parliament in the 1560s. There is, for example, Jerónimo de Blanco's statement of 1585 that no other assembly, however large and universal it can be, truly represents the kingdom of Aragon or its 4 estates, but the Cortes. The Cortes Generals in Valencia was referred to in 1677 as the universal congregation of the people of the entire kingdom. But the reduction of the Castilian Cortes to 1 estate only after the refusal of the nobility to pay the excise of in the Toledo Cortes of 1538-9, the way in which the cities treated the Cortes as purely a forum for exchange and negotiation rather than decision, demonstrated the lack of a single political community there, or at least the absence of a confidence in the justice of the process. The same might be said of the practice of dissentiment in Catalonia, where a single objection to specific proceedings by a single member of any estate could halt all other business. The abstention of the Basque provinces from the Cortes of Castile similarly shows how ideas of a political community attach naturally to smaller units, particularly cities, or a señorío or province like Bizkaia or the other Basque territories. We might think of these as equivalent in some way to the smaller units that existed in England, towns and county communities. These did possess political assemblies of a sort. The meetings of county courts bringing together a local elite worked as a forum for the exchange of views locally. But in England, these were not nearly so well developed as political fora as they were in Spain. They had no formal political function apart from elections. In Spain, distinct local customs and legal systems naturally made these local units much stronger as communities. The assertion of a common noble status, for example, no doubt created in Bizkaia a particularly powerful identity as a political community. In the late 16th and early 17th centuries, it became very clear that there could be very different ideas about what representation meant. A royalist interpretation in England was that the representatives were merely providing government with information about the state of affairs throughout the country so that it could respond as it saw fit. But an increasingly common interpretation went much further than this. Representatives were expected to act as interpreters of and advocates for their local communities as well. For Kings James I and Charles I in the 17th century, the claim carried an implicit danger for their own status, challenging the idea that they themselves were really the nation's true representative. The point raised another ambiguity within Smith's conception of Parliament, which also became significant in the 17th century. Was the king part of the community as assembled in Parliament, or did he stand outside it? He could be regarded as within it, along the lines of the common metaphor of the body politic, with its controlling head, the king, and obedient limbs, everybody else. But the origin of the idea of the communitas regni suggested a community separate from and potentially opposed to the king. It hinted at a corporate identity that could negotiate with the king and could be interpreted and represented. In the late 16th century, one can recognize a tendency towards the consolidation of such an identity within Parliament, with the development of the idea of the privilege of Parliament, a set of rights attaching to the parliamentary body as a whole, which it was important that the king should not violate. This was never taken in England to mean that Parliament constituted a separate interest and corporate identity independent from the king, at least until the beginnings of the Civil War in 1642. And even then, Parliament, while fighting the king, claimed to be doing so on behalf of the king in Parliament. The Parliament had no particular institutional identity separate from that relationship. It had no executive officers, it had no seal, and neither did either of its two chambers, at least until the creation of a republic in 1649, in which the identity between Parliament and national community was made very explicit. The strength of the idea in England that the king was part of Parliament perhaps resulted from the fact that the king was usually present. In Spain, although Aragonese political thinkers made statements concerning the king's involvement within the Cortes very similar to Smith's statement, the idea was much less potent, perhaps because, in contrast to England, kings were frequently absent from meetings of the assemblies. Parliaments in England never developed the executive or oversight structures that various Spanish kingdoms did. The formation in those kingdoms of executive authorities that were elected by and directly responsible to courts or cortes did not happen. There were attempts in the 14th century to create machinery for the government of the kingdom that was answerable to Parliament rather than to the king himself, but none of these was long-lasting or effective. There was nothing similar to the creation of the Generalitats and Diputaciones in the kingdoms of Aragon and Valencia, or to the delegated bodies in Bizkaia and the other Basque provinces, regimentos and diputaciones. This is, I think, a very significant difference from the tradition in Spain and offers a way of distinguishing between constitutionalism and pactism. These structures imply a much more enhanced corporatism than in England. They reflect the fact that the king governs multiple communities and has different relationships with each. In the general courts of Aragon at Monzon in 1382-4, when the assembly articulated a theory of the union of all of the elements, king and the separate estates, in a single res publica, the king insisted in response that the various members of the body could have separate and conflicting interests, and that the king could not be regarded as being part of the assembly but stood outside it. Such a distinction is difficult to imagine taking place in England. If one issue in defining the relationship between early modern Spanish pactism and English constitutionalism is the nature of the representative community and its relationship with the sovereign ruler, the other is the nature of the pact or the constitution itself. In both England and Spain, there existed agreements of one sort or another about the structure and government of the state and laws, whether or not of customary origin, were increasingly written down, even if only in the records of the decisions of judges. In both Spain and England, the system involved oaths on the part of the ruler that those agreements and laws should be respected. But there was no provision for adjudication of disputes between ruler and subjects, no strict form of interpretation of what these terms mean. There was often no clear evidence of the terms of the pact or what real authority it had. At what point was it acknowledged that the pact has been disrespected? Was it a contract with the possibility of withdrawal, or something that was merely a commitment on both sides with only political means of enforcement, depending on the strength of the respective forces? These were matters of constant concern during the history of both countries, but they become particularly significant during the 16th and early 17th centuries. Indeed, the late 16th century saw across Europe a focus of attention on the protection of the privileges of the political community. One result was a stress on their antiquity. The origins of dynasties and political communities throughout the continent were already extensively mythologized, just like those of Bizkaia had been by Barcelos and Salazar in the 14th and 15th centuries. They often already contained critically the idea that there had been some sort of foundational agreement between an elected lord and a territorial community, as in the Aragonese laws of Sobrarbe, confirmed in the version of the Fueros published by the Aragonese Cortes in 1552. They were a natural recourse for those seeking to preserve old privileges against the attempts of kings to assert their control over their subject peoples, particularly in the context of religious rebellion and confessional warfare in the 1570s and 1580s. The French wars of religion were a catalyst for the anxious assertion across the continent of monarchical sovereignty and popular rights. While Baudin published his criticism of limited government in the 6 books of the Commonwealth of 1576, the ancient roots of modern constitutions were most obviously asserted in François Hotman's Franco-Gallia of 1573, which made reference to, and therefore popularized beyond Spain, the laws of Sobrarbe. The pseudo-historical legitimacy that the legend gave to Aragonese constitutionalism was therefore thereafter defended and celebrated by Jerónimo de Blancas in 1588 and became embedded in the Europe-wide discussion of the power of monarchs and the privileges of subjects. The same moment saw the publication of other originalist defences of popular privileges. Calças de Catalonia of 1588 claimed an original contract between the Catalan people and the Carolingian monarchs, and Andrés de Posa's defence of the Bizkaian nobility similarly asserted the autonomous status of Bizkaia. If the notion of community was much broader and more comprehensive in English constitutionalism, the element of contractualism, the transactional element, was much weaker. Perhaps that was partly because the Norman conquest of 1066 made it difficult to claim, as Bizkaians were able to claim around 1700, that we did not enter the crown of Castile by blood, conquest, or donation, but by the voluntary union of our crowns and their covenant with our master the king. Whatever agreements had been concluded concerning the way in which kings could exercise their power, before 1640 no one advanced a claim that the English monarchy was elective or that there was a right to withdraw obedience in the case of non-fulfillment by the crown. The central cases in subsequent discussion were the depositions of two kings, Edward II in 1327 and Richard II in 1399. In both cases, the political elite had been careful to involve the community and parliament, and the acclamation of the replacement looked like that looked like what took place at a traditional coronation might suggest an elective process, but the proceedings were carefully managed to imply that the king had voluntarily abdicated rather than been removed. The implication, in other words, of parliamentary authority in the making and unmaking of kings was avoided. That changed in the crisis of the mid-17th century, as it became more common, though still highly controversial, to refer to a contract and to stress the reciprocity and conditionality of royal power, as well as to allege the non-monarchical origins of the common law and parliament. No doubt there was some influence from the debates in continental Europe, Francois Hotman and Jean Baudin. A re-evaluation of England's early history also contributed to changes in the way its constitution was conceptualized. The Reformation provided a stimulus for a scholarly focus on the development of English political institutions. Keen to read the parliamentary settlement of religion in the 1530s back into the distant past and to confirm the point that the Pope had never exercised any jurisdiction or influence with the kingdom, commentators in the late 16th century discovered in the Anglo-Saxon Assembly a parliament which they saw as equivalent to their own and attributed to it the introduction of Christianity into England. The idea that Parliament had a history that stretched back well before the Norman conquest, that it was among the founding and essential institutions of the English state, solidified into a popular orthodoxy. This was not an argument about the precedence of parliaments over kings or a claim that parliaments had the power to elect or to remove their kings, but in dignifying Parliament with great antiquity and authority, it implicitly suggested a challenge to royal prestige and ultimately perhaps power. And by the early 17th century, it encouraged an explicit interest in contract in legal and political theory. Numerous commentators referred to the coronation oath by the early 17th century as a contract between king and people. They include the great lawyer John Selden, or a bold member of Parliament who talked about the people's voluntary assent to an original contract between king and people in the 1620s. The confrontation between king and parliament in the 1640s made the question into a vital one about the nature of political obligation within the English constitution. Parliamentarian propagandists argued that supreme authority in England belonged not to the ruler, but in the words of one of the most prolific of them, William Prynne, to their kingdoms, senates, parliaments, people, who not only had a power to restrain, but to censure and remove their emperors and princes for their tyranny and misgovernment. Prynne especially explicitly made the comparison with Spanish and especially Aragonese fueros in an extensive survey of the contents of Juan Marijuana's Historiae de Rebus Hispaniae to prove how common were contractual relationships between kings and communities, and how common it was for kings to be held strictly to the terms of their contracts. The royalist philosopher Thomas Hobbes tried to neutralize such arguments by emphasizing that whatever the historical evidence, there could be no justly enforceable contract between the sovereign and a political community. Radical politicians and theorists such as Algernon Sidney in the 1670s continued, though, to insist that there was a contract and that it incorporated a right to withdraw obedience. But it was too controversial to be incorporated into any official doctrine of the state. When James II fled from the invading army of William III in 1688, he, like Edward II and Richard II, was deemed to have abdicated rather than been deposed, although he had plainly done no such thing. The issue remained one for a dwindling number of theorists for a good deal of the 18th century, but by then it had moved on to another plane. The Bill of Rights, accepted by William III and Mary II in 1689, was not explicitly a contract. William strongly resisted the idea that his accession as king was conditional on his acceptance of it, but it was widely taken as such, and William and his successors were forced to recognize that government was impossible without respecting its terms. Ironically, the substitution of the sovereignty of Parliament for a vaguely defined royal sovereignty created a body that had no very effective balancing force. For if the relationship between a king and a parliament was now a contractual one, and if there was an implied contract between the parliament and community that elected it, it was one that was no more enforceable than parliaments had been against the king. The combined power of Crown and Parliament after 1689 created a state authority that was potentially, if an administration commanded a strong majority in Parliament, much more concentrated, vastly more absolute than anything available elsewhere in Europe. With its ability to pass unchallengeable statute law and the lack of a code which regulated the way in which Parliament could behave, the potential for the oppression of minorities was obvious. Rousseau famously commented that the English people were free only once every 7 years when an election was required, contrasting the casual delegation of a sovereignty rightfully in the people to a representative assembly with the retention of direct power over executive government by the people of Geneva through assemblies at which all people could be present. Ironically, as in the 19th century, Britain and other European states extended voting rights to more and more people, not just those with substantial property, it simply enhanced the strength of the representative parliament further, giving it the legitimacy it had previously lacked. The power of democratic sovereignty left no reserve, no hiding place against the power of an increasingly uniform and impersonal modern state, no balancing authority to which one might appeal. This perhaps helps to explain why, by the 19th century, the localism and direct democracy of the Bizkaian state appealed so much to some English Romantic commentators when they were threatened, firstly by Napoleon in 1810, and then by the modernizing demands of the liberal constitution. While Wordsworth idealized the lofty-minded lawgivers who meet peasant and lord in their appointed seat as the guardians of Biscay's ancient liberty, the Earl of Carnarvon, in his passionate account of his journey through Spain and Portugal and review of Spanish affairs of 1836, bitterly reflected on the British government's support for the Liberals in the First Carlist War, and referred to the Basques' generous and exalted sentiments of liberty, and compared their constitution to that bastard freedom which respects not the means, so the end be obtained, which in spirit is based upon a principle of absolute equality, which has no toleration for any class of opinion or line of conduct but its own, and which rejects liberty itself in its purest form, if clad in a garb of antiquity and divested of that uniformity which is an essential ingredient of that narrow system. Wordsworth's celebration of the Biscayan constitution reflects his increasingly conservative tendencies. Carnarvon had been a Tory, conservative, member of both Houses of Parliament and hostile to British political reform. But surprisingly, given the prejudices of conservatives for such ancient arrangements, neither celebrated the British equivalent, the ancient freedom of Anglo-Saxon England. That remained the territory of liberal radicals, but even they, while reveling in the ancient origins of Britain's constitutionalism, increasingly saw them as more picturesque than practical. As with Biscay, it could be symbolized with an oak. J.R. Green's Short History of the English People of 1874 tracked the origins of Parliament to Schleswig, the supposed German origin of the Anglo-Saxons, and the Moot Hill or sacred tree where the community met from time to time to order its own industry and to frame its own laws, as did their descendants, the men of a later England, meet in Parliament at Westminster. Green was the most extreme of a number of historians who, despite the oak, ignored the history of Biscay and regarded such institutions as instead the heritage of a family of Northern European peoples, a tendency that became, in some hands, almost explicitly racist. For many such commentators, these origins were just increasingly irrelevant to the modern state. So too was constitutionalism and pactism. The modern democratic state instead followed the anti-constitutional principles of Baudin or of Hobbes. It struggles, therefore, to understand ideas of limited power and a fundamental constitution. When Britain rejected the EU in the Brexit referendum of 2016, it was perhaps just reflecting how the weaker traditions of English-British constitutionalism could not resist a democratic sovereignty that had inherited the centralized power of English kings. Thank you.
Thank you, Paul. 10 minutuz galderak, komentario edo zerbait norbaitek nahiko balu, oraintxe daunea. Abrimos un turno de intervenciones para quien desee realizar alguna pregunta o comentario a la ponencia de Paul Seaward. Well, I will ask last. I don't know. Well, I will comment something about your paper. In the case of Spain, that it is necessary to underline the composite Spain until 19th century, because for one, there is the Castilian crown, the Aragon crown, the Navarrese crown, and the pactism system. And it's interesting your suggestion about this parallelism between constitutionalism and pactism. But the concept of pactism in Spain is very different in the Aragon Crown, Castilian, or Navarrese Crown. It's not equally the same different kingdoms. That's what is necessary to specify a little bit to make a comparison with the English case or British monarchy. That is a comment to understand better. And in the Bizkaia case, within the Castilian crown, this contractual view is clear in 17th century. We have a picture outside made by Mendieta that it tried to represent this contractual point of view. Not accepted, of course, by the crown, but from the Bizkaia Assembly that was the concept in 17th century and 18th century. That means that pactism, in general terms, in Spain, is not quite useful concept. It's necessary to underline a different crowns of different, in case of Bizkaia, the Bizkaia assemblies, the territory, like in England, in respect of with Scotland or Wales, probably, more or less. That's to understand and to underline the composite kingdom that represents the Kingdom of Spain.
Thank you, Josipa. Yes, that's interesting, and I've spent some time trying to understand what Spanish historians and constitutionalists mean by pactism, which is, as you say, not consistent across the whole country of Spain. There are very many differences, but I think what I tried to, what I felt was that it is nevertheless a term which is used for the more broadly for the whole concept of having an agreement, having a some sort of explicitly stated agreement, and I wanted to try to understand the extent to which that is similar to something that we have had and is celebrated almost in Britain as an invention of English, the English system. Of course, it isn't. I mean, it's very, in a way, this system is very, very common across Europe. There are many other countries in which it happens, almost ubiquitous, and they all have variations, whether we're talking about Poland or Sweden or all of the states of, all of the princedoms and so on of Germany, Italy, and so on. So I think I was trying to look for the common factors within them and do some comparisons. What I didn't want to do is what so often happens, which is that one tries to say that one system is a better one than another one, or a more lasting one than the other one. They all have they all have their successes and their failures. And I think I also wanted to emphasize that actually some of the ways in which these agreements have developed in Spain mean there is a much stronger, that the tradition of constitutionalism is much stronger in Spain than it is in Britain. And that's also true of some other places in Europe. We think of the British Constitution as a very strong model, but actually its protection for the individual are fairly weak, or at least were weak, until we accepted the European Convention on Human Rights and joined the EU. Now they're a bit weaker again. Thank you.
Nik algun galderaren bat, bai. Itxaron, mikro emango dutzu, Xabier Zabaltza.
Well, to begin with, I would like to thank you for your excellent paper. It sounded to me very interesting because it made me realize that we belong to the same tradition. I think it's quite similar. And I think there is a very important concept which is in force in Europe, which is the concept of representation, which doesn't exist in other civilizations. I think it's a crucial concept. Sometimes we don't realize how important it is. And I had two questions. The first one, I didn't get what you said about sovereignty. I didn't understand very well whom the sovereignty belongs to. And the second idea is, well, you said something about Scotland, something about Wales, but you didn't even mention Ireland. I'm sorry.
Thank you very much. Two very, very good questions. To who does sovereignty belong? That's it's as arguable as the relationship, as the representational relationship. I mean, a king would. The idea of sovereignty is not a very well articulated one before the late 16th century and Baudin, or more particularly in the 17th century and Hobbes and so on. So the idea of exactly what sovereignty means, that it's about legislative supremacy, which is our current view, is not really there very solidly. And I think most people would have assumed casually that the sovereign was the king. I mean, English ordinary language still retains, we still refer to the king as our sovereign very peculiarly. So I think, I mean, legally now we would, Parliament is a sovereign legislative authority, but of course it is an elected body, and therefore one talks about the people as sovereign. But Rousseau's point that means you're only sovereign once in every 7 years at the time is a perfectly good one. I'm afraid the bit about Ireland I cut because I thought it was getting too long and complicated. Ireland is, of course, both is a fascinating part of this story because it's assimilated into the British kingdom very late, only in 1800. Does it become part of the Union, and then it leaves again 118 years later, and there is a constant argument throughout those 118 years about its status and the level of its autonomy. From 1800 to 1918, there is no significant autonomy left, which makes it slightly different to the Scottish case, which in Scotland, though there's no political autonomy, there is a separate legal system, a separate church system, and so on, which is retained. In Ireland, that doesn't happen, though there's some, that's not completely true, but broadly true. And we still have this question of Northern Ireland, and it's made even more complicated by its relationship to the Republic of Ireland and the strange status that it has come out of, the strange status it has had after Brexit. I hope that sort of answer your question. I can't quite fold it into my argument since it's not a since it doesn't work in quite the same way. But I mean, in terms of constitutional relationships, it's fascinating that the relationship between Britain and Northern Ireland is now governed essentially by part of the European Constitution, despite the fact that neither Britain nor Northern Ireland are part of the EU. It's a very bizarre and anomalous situation.
Thank you. Bueno, eskerrik asko guztioi. Orain ordu erdiko etenaldia daukagu, eta ondoren Marisabel del Valen hitzaldia Castillako ikuspuntutik. Media hora para tomar un café y a las 11:30 estaremos con Marisabel